A child is taken across the border, one parent left behind helpless, the other in hiding. You turn to the Hague Convention, promising return, speed, protection, but then nothing moves. Delays, defenses, confusion. That's when you realize even a strong international treaty depends entirely on how a court or country applies it. And in South Africa, that application still has troubling gaps. I'm Simon Dippenaar, a family lawyer based in Cape Town. For over 4 decades, the Hague Convention on the civil aspects of international child abduction has been the global response to one parent wrongfully removing a child across borders. It's supposed to work fast, but in South Africa, from 2020 to now, cases have revealed delays, legal misinterpretation, and procedural inconsistencies. In this video, we'll explore what those gaps are, why they matter, and how we can and must fix them. Part 1. The law's intention versus our courtroom reality. The Hague Convention is clear. If a child is wrongfully removed or retained and a return application is filed within 1 year, that child should be returned promptly. 6 weeks is the international standard. But in Koch versus Ad Hoc Central Authority, South Africa's Constitutional Court reviewed a case that took 4 years. 4 years. But then the child had bonded with relatives, settled in school, and courts hesitated to disrupt her world again. So the return was denied. The convention's very goal, swift return, was erased by time. Part 2. Misusing the grave risk exception. The most exploited loophole in the Hague Convention case is Article 13b, grave risk. In theory, it's reserved for extreme cases, abuse, danger, trauma. But in LD versus Central Authority, the court refused return because the child had grown attached to a half-sibling and stepfather in South Africa. The risk wasn't grave, it was inconvenient. In HR versus Central Authority, a mother argued that returning to Canada would trigger her postnatal depression. The court agreed, again denying return. And in MB versus LC, a father's agreement to a temporary stay was twisted into long-term acquiescence. Each of these cases illustrates a core concern. South African courts at times treat Hague return hearings like full custody trials. They weigh parenting plans, emotional bonds, school preferences, when they should be asking, was the removal wrongful? Is return safe? Is it urgent? Part 3, procedural breakdown and delays. Now let's talk delays. Hague Convention Article 11 and our own Children's Act regulations demand resolution within 6 weeks. But N versus M versus Central Authority decided by the SCA in late 2024 exposed the truth. The High Court sat on a Hague matter for 6 months after hearing. No explanation, no urgency, no regard for the child's rights or our international obligations. And the Supreme Court had to say it plainly. Time cannot be used as a weapon by abductors. Every day a case drags out increases the chance the child will be considered settled in their new environment, and return becomes harder. This is not legal nuance, it's structural failure. Part 4, Central Authority and enforcement gaps. Our Central Authority is the chief family advocate. It's supposed to lead the return process, facilitate applications, liaise with foreign governments, assist courts. But in CAR versus Central Authority, the SCA noted the CA was absent at appeal. Critical undertakings weren't filed. Nobody briefed the court. Result, confusion, delay, and uncertainty. If the body meant to hold the case together disappears, how can judges make urgent, informed decisions? We need funding, we need protocols, and most of all, we need consistent participation. Part 5. When delay becomes strategy. Perhaps the most dangerous trend is this. The longer you fight, the better your case becomes. A parent abducts, they file delays, they say the child is settled, or that return now poses grave risk. Suddenly, the very act of wrongful removal, if timed well enough, is rewarded. In Koch, the child's life had already changed, and the question became, do we disrupt her again, or let the abduction stand? Part 6. Reform is happening, but not fast enough. There is hope. The SCA has issued strong guidance. Provincial courts are drafting practice directives. The Rules Board is reviewing expedited procedures. Some judges have begun separating constitutional arguments from Hague applications to prevent legal distractions from hijacking return cases. But what's missing is uniformity. Not every court is on the same page. Not every judge understands the Convention's intent. And without clear procedures, justice remains inconsistent. We don't need to rewrite the Convention. We need to apply it with focus, urgency, and integrity. South Africa must rein in misuse of Article 13b, train judges in Hague procedure, empower the Central Authority, and enforce the 6-week rule, because justice delayed is not just justice denied. It's a child's life left in limbo. I'm Simon Dippenaar. Let's close these gaps for good.